at Lamson Cutner. They are a preeminent elder care and estate planning firm. They advise seniors and their families and people with disabilities on estate planning and healthcare planning. The firm's services also include Medicaid planning, and we're going to have a special webinar about that in September. Just want to give you a heads up about that, and the preparation of Medicaid applications. David has written numerous articles on elder care law topics, including his booklet, 25 Strategies to Prevent Financial Ruin from Long-Term Care Costs, something we all want to be aware of, which was recently published in its 4th edition. So David, welcome. Thank you for being with us.
Well, thank you, Mim. Happy to be here and talk about one of my favorite subjects, wills and trusts. So let's get started.
Great. We're going to just jump right in. To start, what are some of the basics everyone should know about a will?
Yes. I think this is an interesting topic. I know everybody's heard of wills and a lot of people have wills. One of the things that always interests me is a lot of people don't really understand the basics of how wills actually work. And I think the place to start is the fact that, you have a document that says last will and testament. And presumably that document expresses your wishes regarding the distribution of your estate upon your death. And you're expecting that to be enforced, and you name an executor whose job it is to do that. So the first point is that every single will without exception is just a piece of paper until that piece of paper is presented to the surrogate's court with a probate petition. And once that probate petition is filed, family members are required to be notified. A hearing date will be scheduled. They have an opportunity to come and object if they choose. They can demand discovery. They can ask for depositions of the witnesses to the signing of the will, of the attorney who supervised the signing, and other things. So before you know it, we're off to the races in court. And even if there's no contest or no objection, it still takes time. We're in court. We're waiting for clerks and judges to do their job. And sometimes we're just waiting and waiting and waiting. And why do we have to go through all of that? Well, it starts with that first word on the document, last, the last will and testament. So I think, as we all know, you can do more than one will. So if you've done a will 10 years ago and today you do a new will, well, your new will revokes the last one. So if we're in court, the judge wants to know, is this the last one? And by the way, if you tried to go to the bank without filing a probate petition and getting a court order appointing you as an executor, you would find out that's going to go nowhere. The bank's going to tell you, well, come back and see us when you have letters testamentary from the surrogate's court, which authorize you to collect the assets of the estate. So bottom line here, you have a will, you want it to express your wishes regarding your estate. Somebody's going to have to go to court. They're going to be spending money on legal fees. They're going to be waiting and waiting for the clerks and judges to do their job. It can get a little aggravating. And in some cases, fortunately, a minority of them, there is a contest, and then things get unpleasant and even more drawn out. And then I think the other big point that's useful to know about wills is your will governs only those assets that remain in your individual name when you die. So obviously, many people, if they own a home and they're married, the title to the property is going to be in joint name. So it'll be a joint tenancy between the two spouses, or it'll say tenancy by the entirety, which means the same thing. If one spouse dies, the other owns the home automatically. It's not a probate asset. If we have a joint bank account with a spouse, with a child, with somebody else, one of the joint owners passes on, the surviving owner is the owner of the account. You can say something different in your will, it won't matter. It's the title to the account that will control. I'm sure many of you have retirement accounts. You have an IRA or a 401k. You've named a beneficiary of that retirement account, or maybe a savings account or another kind of account. If you die, that account belongs to the designated beneficiary. It also is not a probate asset. So in a typical case, we often have assets that are passing outside of the will. So again, it's only those assets that remain in the decedent's individual name. There's no beneficiary, there's no joint ownership. Those are the assets that are governed by the will.
Right. Thank you. And I think it's really interesting information, because again, we tend to think that wills are going to cover everything. So I really appreciate you sharing. There are very specific things we need to know about, and different ways of approaching that depending on what your care plan is, and getting the right advice around that. Is there anything else besides what you shared that would fall outside of the instructions that you might have in a will, or do you think what you've shared is pretty much the basics?
No, there are a couple of other major areas that might fall outside the will, or be notwithstanding the will. So the first major area would be trust. If we have a trust, then whatever the trust owns is governed by the trust, not by the will. And I think we're going to talk a little bit more about trust today, I think, Mim.
Yeah.
And the other area is there anyone that we cannot disinherit? Answer, yes, a spouse. So if you have a spouse and you're legally married now, you cannot disinherit your spouse. And there's something in law called the spousal right of election. So let's say we have a will that leaves everything to the children, or to the siblings, or to charity. If we have a surviving spouse, he or she has a right to a third of the estate. Now, on the other hand, I know lots of children feel that I have a right to mom or dad's estate. Actually, no, you don't. If mom or dad wants to leave their money to charity or to somebody else, you do not have a right here. So I think that comes sometimes as a surprise. And there are situations where somebody wants to disinherit a child or children, and sometimes with good reason. Sometimes I'm thinking of a particular case now where one of our longtime clients who had 4 children, and he had 2 sons, 2 daughters, and his sons had been very successful in business and were quite wealthy. The daughters, not so much. And he said to me, my sons are fine. They've got lots of money. They don't need my money. The girls haven't done so well, and really they're the ones who've paid attention to me and helped me. in my senior years, I really want to leave my money to them. And I said, well, let's be careful here. Your sons, even despite the fact that they don't need the money, they may feel resentful about not receiving anything. And he said, well, if they want to think that way, they can discuss it with me after my passing. And he wound up leaving everything to his daughters, and that did start World War III. And so they've had a litigation going on for about 3 years now, and it's been pretty unpleasant.
No, I think
So
that brings up a really good point about, right, what is in that will and how is it worded? So really appreciate that story, because I think it really underscores the need to understand what needs to go into a will and how it needs to be positioned in order for your wishes to be carried out. But what if it's worst case scenario? What if you don't have a will?
yes, well, that is often the case. Somebody doesn't have a will. What happens now? Well, when we don't have a will, the law of the state where we live will tell us who has a right to the estate or a share in the estate. So these are called laws of intestacy or intestate succession. Intestate means without a will. So every state has these laws, and I haven't done a survey of what other states look like, but I can tell you what it looks like in New York, and I imagine that it's pretty much the same elsewhere. So if we have a spouse and no children, the spouse inherits everything. If we have children and no spouse, the children inherit everything in equal shares. If we have a spouse and children, then the spouse gets half and the children get equal shares of the other 50%. So if we don't have any of those, then we look to parents, and then we look to siblings, and then we look to nieces and nephews, and then we look all the way down to first cousins. And makes me think of another interesting case, Mim. We had a client who, sort of unusually for us, was a pretty wealthy woman. She had, I don't know, $8 or $9 million, I think, in her estate. And she wanted to leave everything to charity. She wasn't married. She had no children. And I think she had, I don't know, 21 or 22 charities that she wanted to benefit from her estate. And it took a long time to do her will, and it wasn't complicated for us, but it was complicated for her because she kept changing her mind about how much do I leave to this charity and how much do I leave to that charity, and should I leave something to another charity I hadn't thought about for a while. And anyway, it sort of went on and on. And I would say to her, look, let's make up our mind here and get your will executed. Well, it went on for a long time, and eventually she died without signing her will. So did any of these charities benefit from her intended generosity? No. The laws of intestate succession took over, and the persons who inherited were two nephews who were estranged, and she hadn't spoken to them in about 30 years. So these two guys sort of walked away with a fortune. It was like winning the lottery without even buying a ticket. And that's how it turned out. That's unfortunate. So,
well, I think it really gets to the point, David, of saying, it is sometimes difficult, right, to make those decisions, and you might be going back and forth, but you can also change the will or add a codicil to the will. So I think that story really underscores the need for getting something in place. It doesn't mean that you can't change it. It doesn't mean that you can't add things to it. But I think if you don't do it, this is the kind of situation you can potentially get your family or loved ones in. And
Yeah,
so
that's exactly right. And I think there's so many people, and it's hard to argue with this. Who wants to think about getting old and sick and all of that? Nobody wants to think about that. And so, so many people put it off. But when they finally get around to doing it, they all express, relief uh, and a feeling of comfort, that it's taken care of, and I think they walk away much comforted from having done it.
they now know that their wishes are going to be carried out. And I think that's so important for so many of us. And maybe we don't want to think about that, but I also believe it's truly a loving thing to do for those you care about, or a compassionate thing to do, to your point, if you want to give money to causes that are very near and dear to your heart. So yeah, peace of mind is top of mind for all of us. Well, we've talked about wills and really appreciate that. But I think for some of us, we're not really knowledgeable about what is a trust. So would love to have your take on what a trust is, types of trusts, and the benefits.
Yes, that's also a really important area, and really a more efficient way of doing estate planning, because nobody has to go to court. And I think that's a good thing. I really do. I don't think anybody benefits from going to court other than lawyers. And
I'll put.
and even that's so, I don't like seeing our clients in court. I know they're not going to be happy. I really would prefer that not to happen. Okay, so what is a trust? I think, and I say this all the time to new clients, the best way to think about a trust is think of it as another person. It's somebody other than you, all right? And a trust starts with a document, but I want to emphasize that it starts with a document. When you do a will, you've done the document, you've done your will, that's it. There's nothing else to do. The rest of it is carried out by your executor after your death. But when you do a trust, it starts with an agreement called the trust agreement. And the agreement is between you and the person who is going to administer the trust and take care of the assets in the trust. So that brings us to a distinction. There are different types of trusts. So the first trust I'm going to talk about is called a revocable or living trust. The goal of the revocable trust is mainly to avoid probate and also keep your matters private, because it's not in court, it's not public record, it's just between you and those who are concerned by your trust. So in many ways, your trust looks like your will, except it's an agreement between you and the person who's going to administer the trust. When you have a revocable trust, you can be that person who administers the trust at the same time. So you are both the creator or grantor of the trust, and at the same time, the trustee of the trust. The trustee being the person who is managing and administering the trust assets. So a lot of people like revocable trusts because you don't give up control of your money and property, you're in charge. But as a legal matter, the trust owns the assets, right? So you own a home, you have to do a deed that says now, let's say it's my trust, okay? I own my home, it's in my individual name with my wife, and the two of us decide to create a trust. We're going to sign a deed that will say that the Cutner family trust now owns the house that we live in, right? And if we want to put our investments into the trust, we're going to call our financial advisor and say, look, we need a new account, put it in the name of the Cutner Family Trust, and my wife and I will be the signatories. We're the trustees. But now the trust owns our investments. So if we die, the will has nothing to say about the house, the investments, the cash, whatever we've put into that trust now is governed by the trust. And in the trust agreement, we have named a successor trustee who takes over after our death. That person, who can be our son, our daughter, our sibling, whoever we want, that person's job is simply to distribute the assets that are in the trust. Very efficient, very simple. Nobody goes to court. Saves a lot of time and aggravation for surviving spouse, surviving children, whoever we want to benefit. So that is our revocable trust or living trust. I think I also would like to mention a couple of other kinds of trusts. One of them is called an irrevocable trust. Right? So the irrevocable trust is what it sounds like. It's not revocable. And the other difference is that you cannot be your own trustee. You must name an independent trustee. So the independent trustee could be a child or your children, could be a sibling, somebody close to you. Normally would be the trustee of the irrevocable trust.
Can an attorney, your attorney, be named?
An attorney could be, if he or she is willing to accept that role. Sometimes bankers, when there's a trust department, they are willing to do that. Sometimes care managers, daily money managers, other people who kind of work in the elder care space. Sometimes they are willing to take on that role as well, for people who don't have someone close who they would like to have as their trustee. So I guess the thing that causes hesitation, if there is hesitation about the irrevocable trust, is to a large extent, we have to give up control to our trustee. We cannot be the trustee, right? So why would we want to do that? Well, there are actually some good reasons why we might want to do that. And one of them sort of makes me think of this little saying that I have, which is, wills and trusts are great, but will you have an estate? And one of the goals with your irrevocable trust is it's protective of your assets. It will protect your assets against the claims of any future creditor. Why? Because they're not your assets anymore, right? So if the Cutner Family Trust is now an irrevocable trust, and the trustee is my son, I don't have a signature on the bank account. I don't have any control over those assets. So if you're a creditor and you come to me and say, pay up, buddy, I may not have any money left. And it doesn't matter that all of my assets are sitting in that trust, because they don't belong to me anymore. And the other, maybe even more important reason that we find, at least in our law practice, is the healthcare issue. And I think for most seniors, probably the biggest financial risk is healthcare. What if you need care in the home, assisted living, nursing home. It is just so expensive. In fact, our top court in New York called long-term care expenses, I'm quoting now, ruinous. And they are for most people. It's just so expensive. Who can afford it? Who among us can spend $15,000 or $20,000 a month on healthcare? And
When you say healthcare, David, I think it's important to recognize, I mean, we tend to think of that as like going to the doctor, but I like that you say aids, home renovation to modify a home, capital expenses that may be related to that. So on our last webinar, we talked a little bit about high level about what a financial care plan is and how that has to be married to exactly what you're talking about, that there is not just about saving for retirement. There are very specific costs and ways to protect assets that you can protect legally through a lot of what you shared. I know we just basically touched, we're almost at the end of our 30 minutes. Hopefully everybody that's listening in learned a little bit more. Obviously, legal considerations have to be based on your particular needs, wants, situation. And so this is why we at Nativity Care are big advocates to making sure that you get to the right resources that can credibly walk you through your options and make sure that you're better protected. We're happy to take questions. If anybody would like to, throw those in the chat, we're more than happy to do that. I say, are there recommendations online? So I will tell you from the Motivity Care side, no, and I'm going to tell you why. Because just having a resource or links to resources does not give you an idea of whether it fits your budget, what their ethical level of service is, and it is part of what Motivity Care provides. It's to make sure that you get to a resource that can credibly give you what you need. And again, that it's specific to your budget and your situation, and that you don't have to do all the vetting around all those pieces of the puzzle, that gets done for you. So you can go out and look at resources, but I'll give you an example. If you were going to say, well, I want lawyers that know about trusts, you're going to get a big list. And so the question is it the right fit for you?
So, ma'am, let me just add a couple quick comments. I know we're just about out of time, although I'm happy to stay for a little bit if there are questions. The healthcare that I'm thinking about mainly is long-term care. If you're 65 or older, you have Medicare. Maybe you're even still working and you have insurance through your employer. So good medical care is available, probably through the Medicare program, but Medicare does not pay for long-term care. So if you need care in the home, if you need assisted living, if you need nursing home, that's long-term care. That's not covered by Medicare. It's not covered by any medical insurance. And most people don't have long-term care insurance. It's expensive, very expensive. And if you're getting into those senior years, you may not even get through underwriting. Age and health are obviously a factor of whether the insurance company even wants to issue a policy to you. So that's the expense that we're thinking about. And the beauty of the irrevocable trust here is that it facilitates eligibility for the Medicaid program. And Medicaid is the program that will pay for your long-term care. And that's really a big part of elder law practice for our firm and our colleagues who practice elder law.
Great. And I know a little bit over time, but I know, David, you were kind enough. We have some questions. So for anybody that wants to stay on, we want to answer those for you. If you do need to jump off, thank you for being with us. Again, Motivity Care is here to take the complexity out of caregiving management, whether you're dealing with medical, legal, financial, personal challenges. We're here to support you. If you want free information about the services, please contact us And we're happy to get on a free call to talk to you about what your needs may be and get you connected to resources like David's company, to make sure that you get the best information possible. So I'm going to just now jump into some of the questions that we have here, David. I think there's some really good ones. So are all family members notified, or only those mentioned in a will? Is there anybody that, if they're not mentioned in the will, would additional family member be notified when that will is brought to the courts?
Yeah, that's a good question. The family members who need to be notified are those who are called distributees. And a distributee is a person who would stand to inherit if there were no will, right? So we look to those laws of intestate succession, and they tell us who we need to notify. And you can understand why that's important, because what happens if, when the will is presented in the surrogate's court, the judge ultimately finds that the will is not valid, right? So if the will isn't valid, maybe now there is no will, and then we would have to look to the laws of intestate succession. So that's why, disgruntled family members come to court, because they say, gosh, why didn't I get a share? Maybe that will was affected by undue influence, or maybe it wasn't properly executed, or maybe it was procured by fraud, or maybe that's not the last will. So all kinds of issues like that can be raised in the surrogate's court, and that's why distributees are required to be notified.
Great, thank you. Next question is, would it be appropriate to have two separate trusts so that you can maintain control on some assets?
Well, it might be. It really depends what the goals are. I think that if you have money in an irrevocable trust and the goal is to protect those assets and maybe help you become eligible for Medicaid if you need it, that's fine. But if you've got a lot of money sitting in a revocable trust, that money is exposed to creditors and will defeat your Medicaid application if you need to make one. I really don't recall doing two separate trusts of that type, one revocable and one irrevocable for a client. I'm not sure that would make sense. There are times when we do separate trusts for spouses, that might make sense.
Great.
So
I think that's really helpful. So we have a question: does a trust help with the Secure Act and taxes?
Well, a lot of people are worried about estate taxes, and I think surprisingly to a lot of people, there are not a whole lot of estates that actually pay estate taxes. It's something like maybe 0.1% of estates. And the reason is that the exemptions from estate tax are so high. The federal exemption is almost $14 million. So if you're a married couple, you have almost, you have twice that amount. And in New York State, the exemption is almost 7 million. So you got to have a lot of money before you're worried about estate taxes. And I know that comes as a surprise to a lot of people, but at least right now, the way the laws are right now, we've got pretty big exemption amounts. So for those folks who do have a lot of money and they are in a position to worry about estate tax, there may be some strategies where trusts can be helpful. So I would consult an estate planning attorney if that's your situation. So there are some things that can be done. Yes.
Great. Yeah. Again, state specific rules, federal rules. This is why, again, you need the right legal advice. Um, our next question is, some wills spill over to a trust. Are there pros and cons to this?
Yeah, well, that's what we call a pour over will. And that's a situation where you have a trust, and then you also do a will where the sole beneficiary of the will is your trust. So the assets in the probate estate pour over or spill over into the trust, and the trust is the controlling document in terms of the estate plan. So that's where all of it is. It's in the trust. So why would we do that? And we do pour over wills, not all the time, but we do them. And the reason is, um, you know, what if, despite our best intentions to put all of our assets into our trust, something got left out? You know, we forgot about an account, or we received a bequest that we weren't expecting, or a gift that we weren't expecting, a refund that we weren't expecting. And now all of a sudden there are probate assets. So that's why we would have a pour over will. The hope is we won't need to use it, but if it does turn out that we have assets left in the probate estate, and now we know what to do with them. Just put them in the trust, and the trust will tell us how to distribute those assets. And it does make the probate process a lot simpler. But, you know, it does happen all the time. We see this all the time. Somebody forgot about an account. It's got $5, $10, $15, $50,000 in it, and nobody can touch it, you know, without a will.
No, no, that's really helpful. We had a clarification around that tax question. So if there is any way to, I guess, protect your children's assets from the Secure Act, which says you have to take money out of an IRA within 10 years.
Yeah, and if you're a spouse who's inherited an IRA, you have a longer time, but everyone else, yes.
Yeah, so that's just the law.
Yeah.
Yeah, that's really important. We had another really interesting question. So, believe in New York, a spouse is financially liable for their spouse. Must the spouse guarantee payment for their spouse? So along those lines, the secondary question is, do they or do they not sign contracts as a guarantor, third-party guarantor, as a spouse?
Well, you know, that's going to depend on the nursing home, whether they're going to ask for that or demand it, require it, whether they want a guarantee from the spouse. But, you know, I can't speak for other states, but I can tell you in New York, almost every nursing home in New York accepts Medicaid. And I personally can only think of two that don't, at least in the New York metropolitan area. So they all accept Medicaid.
Right, but not like your independent living, like they're right. There's the difference too between like nursing homes and then different types of senior living options, which we're not going to go into today. We're actually going to have an expert on down the road on that particular topic. But I think it's important to note that there's a difference in terms of
Well,
when
yeah, I'm looking at the chat, and the question is about a SNF, which is a skilled nursing facility. So
yeah,
that's why I address nursing home.
I appreciate that.
But spouses, at least under New York law, are, and this is not Medicaid law, it's general obligations law. You are obligated to support your spouse, you know, in the same way that you're obligated to support a minor child. So at least as far as Medicaid is concerned, even though you can transfer all of your assets to your spouse and thereby become eligible for Medicaid in New York, Medicaid does have the opportunity to come back at a later date and say, look, we've been paying for the care of your spouse, and we would like to be reimbursed. So that does happen. Those cases are compromised, usually at a very attractive number, I would say. Um, but yes, there is an obligation of a spouse. But as to whether a spouse has to guarantee payment, at least in New York, I would think not.
Thank you. Well, I thank you for your extra time, David, for the great questions, for everybody who's stayed on with us. Again, we are very grateful to have you with us today and help educate, and hope everybody that is listening or hears the recording gets a little bit more knowledge about why you need to have a professional help you and make sure that you and your family are protected, and to give you that peace of mind, which we all deserve. So thank you again. Please feel free to reach out to us at info@motivitycare.com. We work closely with David and his team, and we have a network, an ecosystem in every aspect of caregiving management to help you and your family and your loved ones. So we also want to invite you to our webinar next month, which is going to be focused on the emotional journey of becoming a caregiver, that we're not always prepared for this and for some of the ups and downs that come along with that. So we're very excited to have an expert come on and help you navigate that journey and protect your own mental health and well-being. So thank you, everyone. We hope everybody has a great day. And again, reach out to us if you have questions. Thank you very much.